Garden State GSCLE. 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 Garden State GSCLE.
The statute went into effect, the amendment to the statute went into effect on September the 10th of this year, and it is applicable to matrimonial cases that are filed on or after that particular date. However, there is certain aspects of the statute that are applicable to matters that are, over, for example, or pending at this point. And I'll show you those exceptions in there. There may be a tremendous source of new business or renewal of business, and I'm going to suggest that when you see something applicable, you contact your clients, your former clients, and say, we may be able to go back and get into court and get a better deal for you than we were able to get initially. Now, the statute, obviously, as being so new, has never been construed by anybody at this point. Many of these issues will be on the fast track to the appellate division, and I suspect within the next 5 years we'll have a dozen cases or so out of the appellate division that'll construe various aspects of the statute. Additionally, we'll get 1 or 2 Supreme Court cases along the way as well, so we'll know more 5 years from now than we know today. So what I'm going to discuss with you today are basically advocacy issues, okay? There's no right or wrong. I'm just going to suggest arguments that you can advance before a family court judge, either, written or oral, things of that nature. And who's to say you're wrong? These judges will listen to you and make the call, all right? So having said that, you guys have a complete copy of the statute. Please be mindful of what I've done to make it easier for you, because it's really an addendum to the old statute. Subsection B is where all the action starts taking place. I've underlined in bold all the stuff that's new, and that's what we'll talk about as we go through the PowerPoint. Everybody ready? Here we go. All right. So the list of amendments basically to the statute dealt with the recognition of civil unions. We still don't have same-sex marriage in New Jersey at this point. The general aspects of the statute then have not changed in the beginning. The only thing that's different, and I just take a look at A. This A deals primarily with child issues and child support. None of that has really changed in the statute. The main change starts with B. All right. Now B outlines the types of alimony that we have in New Jersey, and you're all familiar with rehabilitative alimony, limited duration alimony, reimbursement alimony, all right? And now, in lieu of permanent alimony, that concept has been dropped to this concept of open durational alimony, meaning that there's going to be a beginning, a middle, and an end to it. Now, first piece of legal advice I want to give everybody, and it sounds very presumptuous from somebody who doesn't know what he's talking about. Everything is open to negotiation, okay? And that's what I really want you guys to think about as you hear this, okay? That, you can negotiate anything you want and resolve these cases any way you want. And, there may be a particular asset, for example, that your guy's interested in, and in exchange for that, he's willing to pay alimony, for a time period voluntarily longer than he would normally have to pay it under the statute, or vice versa. So you should be able to utilize the aspects of this to leverage different types of assets to be able to satisfy the needs that your client expresses to you. Now, B is important because of these 14 factors that are listed here dealing with traditional ideas about how much alimony can be paid. I also want to go through them very quickly and show you how they'll interface with the amendments to the statute. So here are the 14 factors under B. Actual need and ability of the parties to pay. And by the way, none of this has changed. This is all the same. Duration of the marriage or civil union, age, physical, and emotional health of the parties, standard of living established in the marriage or civil union. Now, you're going to see this is somewhat abrogated later on because this goes to this concept of the parties being, in a lifestyle to which they're accustomed. There's a recognition now in the statute that that's usually not going to be possible. It's very, very costly these days running 2 separate households. So you'll see that there's some abrogation of this later on in the statute, and I want to sensitize everybody to it now. Standard of living established in the marriage or civil union, and the likelihood that each party can maintain a reasonably comparable standard of living with neither party having a greater entitlement to that standard of living than the other. Earning capacity, education, vocational skills, and employability of the parties. Length of absence from the job market of the party seeking maintenance. You have this, sometimes it'll be for decades. Parental responsibilities for the children. Time and expense necessary to acquire sufficient education and training to enable the party seeking maintenance to find appropriate employment. Availability of the training, employment, and opportunity for future acquisitions of capital and income. History of the financial or non-financial contributions to the marriage or civil union by each party, including contributions for care, education of the children, and interruption of personal careers or educational opportunities. Again, you'll see this is addressed in the new part of the statute as well, looking in particular at professional people, you know, young women who are nurses, attorneys, whatever they are, who forego their career in order to run the house, and a recognition not only of, you know, their lack of earnings during the course of the marriage when they were not working, the opportunity costs that are foregone, but also recognition that they're going to come in at a base salary because they haven't been on the learning curve. So the nurse coming in with zero experience, although she should have 20 years experience, you know, that's going to be a factor to kind of figure in all this, and you'll see that momentarily. Equitable distribution of property ordered and payout of equitable distribution directly or indirectly. Income available to either party through investment or other assets held by that party. Tax treatment, very important in terms of alimony as opposed to child support. Tax treatment and consequence to both parties of any alimony award, including designation of all or a portion of the payment as a non-taxable asset. Here is the amendment, nature, amount, and length of pendente lete support. First thing I'm going to call to everybody's attention, you've got to have your client keep very, very accurate records of the amount of pendente lete support paid, because it could be over a long period of time before you get your day in court, and it's going to be significant. Your client has got to account for every single penny, because he's going to get, for want of a better term, a credit for time served. This is an important factor that's going to go into the mix, and a new one that the judges are going to have to weigh and evaluate. Now, since we're dealing in family court, which is a court of equity, you'll see that the legislature is ending every type of statutory remedy, for want of a better term, with a catch-all expression, okay? And that's number 14 in this particular case, which was in the old statute. Any other factors that the court may deem relevant, but you're going to see this over and over again in the new statute. Every one of them ends with this catch-all, allowing these family court judges to do what they do best, which is to exercise their equitable powers. Now, this is the new part, and it talks about weighing and evaluating these 14 factors. Take a look. In each case where the court is asked to make an award of alimony, the court shall consider and assess the evidence with respect to all relevant statutory factors, all 14 of them, okay? If the court determines that certain factors are more or less relevant than others, the court shall make specific written findings of fact and conclusions of law on the reasons why the court reached that conclusion. This is intended to make a decent record for the appellate division if you have to go there. So they are not operating in a vacuum trying to figure out what the judge meant. Please be mindful that the rules of court limit you to 20 days. If you need to go back and get a clarification or an expansion of the record, you only have 20 days to ask the judge for reconsideration. So keep that in mind if you get a written decision from the court which is either not consistent with what the proofs were, wrong as a matter of law, or the judge missed something significant on interpreting one of the factors, or didn't touch on one of them and you want it in writing. You can go back for reconsideration, ask the judge to provide expanded explanation in writing. You're going to need that for the appellate division. No factor shall be elevated in importance over any other factor, and here's the catch-all, unless the court finds otherwise, in which case the court shall make specific written findings of fact and conclusions of law in that regard, okay? So this really kind of gives guidelines to the court, but remember, this writing is going to be so critical in a contested case in the event that you've got to go to the appellate division. Dealing with retirement benefits, you're going to see there's a whole big thing now dealing with retirement. When a share of retirement benefits is treated as an asset for purposes of equitable distribution, the court shall not consider income generated thereafter by that share for purposes of determining alimony. That was always in the statute. In any case in which there's a request for an award of alimony, the court shall consider and make specific findings on the evidence about all the statutory factors set forth in subsection B of this statute, all 14 of them, okay? Now, first major change deals with length. Okay, there is a presumption in the statute that alimony is going to terminate, be it through marriage or civil union, after a period of 20 years. Okay, so the idea of permanent alimony it's going to go into perpetuity is pretty much done. This is a sea change in the law in New Jersey, a recognition from constituent complaints over many, many years about people whose lives are just ruined. They can never retire. They never have any type of life. They just have to keep working and working and working in perpetuity. Keep in mind also that permanent alimony really serves as a disincentive for people to move on with their lives, in the sense that you'd have many, many instances, and I know, Frank and Eric, you've seen this, where the former spouse is cohabitating with some boyfriend, okay? Why aren't they getting married? Because if they get married, the alimony is going to stop, okay? So it's really kind of a disincentive to, having a legitimate family life. And you'll see that the new statute is intended to address that particular issue. Here's the limitation. For marriage or civil union of less than 20 years in duration, the total duration of the alimony shall not, except in exceptional circumstances, exceed the length of the marriage of the civil union. Now, let's just stop for a second. They define what the exceptional circumstances are, but I'm telling you, as negotiators, you can extend this. You can extend it voluntarily in exchange for something else that's important. Many times it'll be an asset of some type that you want clean title to, all right? Don't think that this is some kind of a cap, because it may be advantageous to you, especially in current dollars, to extend the alimony in exchange for something else down the line. All right? Determination of the length and the amount of the alimony shall be made by the court pursuant to considerations of all the statutory factors in B. That's all 14 of them. In addition to those factors, the court shall also consider the practical impact of the need for separate residences and the intended increase in living expenses on the ability of the parties to maintain a standard of living reasonably comparable to the standard of living established in the marriage or civil union to which the parties are entitled, with neither party having a greater entitlement thereto. This is an expansion of what you saw, I think it's a factor 5, in subsection B, okay? This concept of you have to continue the level of alimony so that she can continue in perpetuity in the lifestyle to which she's been kind of accustomed, that's not the law anymore, okay? It's really a much more reasoned, measured approach to the lifestyle that these individuals are going to have post-marriage. Here's a definition of exceptional circumstances which would allow you to extend the alimony beyond the 20 years. Ages of the parties at the time of the marriage or civil union at the time of the alimony award. So a big distinction here between young people who get married at, in their 20s, and now after 40 years, they're getting divorced, as opposed to people who marry later in life and have a very short-term marriage, something under 10 years. The equities in each of these is starkly different. You'll have to argue accordingly. The degree duration of the dependency of one party on the other party during the marriage or civil union. So you might have an utterly disproportionate issue where for want of a better term, the female stayed home, taking care of the household, etc., and the husband was the working party throughout the entire marriage. Or alternatively, the wife was marginally employed, contributing a little tiny bit, primarily taking care of the household and children. Husband, again, contributing the lion's share of the financial aspects of it. Whether the spouse or partner has a chronic illness or unusual health circumstances, very important in older people where they start to deteriorate through Alzheimer's disease, or cancer, whatever type of disability they acquire. It also could occur as a result earlier in life, generally through, not only through illness, but through car accidents and things of that nature, okay? Whether the spouse or partner has given up a career or career opportunity, or otherwise supported the career of the other spouse or partner. These are two different distinct things, okay? In other words, she's out there working while the other one's in graduate school, law school, medical school, whatever it is, okay? So she's kind of entitled to the benefits of the sacrifice she made to advance his career. Alternatively, is what I indicated before, that the spouse who's a licensed nurse, lawyer, whatever, okay, she has foregone that for a significant period of time during the marriage in order to take care of the children while he's out there doing his thing. So she's behind the 8 ball, not only in terms of opportunity cost, what she could have earned during that time period, but on the learning curve, she doesn't have the same level of experience and is not going to be able to command the same salary that somebody who had 10, 15, 20 years of experience in that field would have. 5, whether the spouse has received a disproportionate share of the equitable distribution. And again, you're going to get this when you have these cases coming where one party is bringing an enormous amount into the marriage, the other one not so much, okay? The impact of the marriage or civil union on either party's ability to become self-supporting, including but not limited to the party's responsibility as primary caretaker, It's related to what we had just said a moment ago, tax consideration, and any other factors that the court deems equitable, relevant, or material. And again, you'll see this happening over and over again, a reminder of the equitable authority that the family court judge has. Now, I want to just talk for 1 second about this equitable distribution business, okay? And it's something that I like to call the speech. I think that attorneys who are honorable and ethical and understand what's going on, who really get it, will have this talk with their clients pretty early on in the, in your representation. Nothing in the world will generate feelings of hatred and revenge and emotion than a matrimonial issue, okay? I like to say, and I'm not trying to be a wise guy here, but it's just a statement of fact. When people get killed in the courthouse, they get killed in family court. That's where the homicides take place, that's where the shootings take place, that's where the stabbings take place. They don't take place in the criminal court, believe it or not. They happen in family court because you're dealing with the most basic human emotions, dealing with sense of betrayal and jealousy and child care issues, and people just dealing with the most fundamental aspects of human beings' emotional life. And a lot of people who are not so stable to begin with, they either can't handle it or they just don't care. So you have clients who are on the razor's edge, so to speak, and many times will do anything to seek revenge upon their adversary spouse. The talk I'm talking about deals with equitable distribution, and the ethical lawyers that I know will say the following. Listen, we can litigate this case as long as you want, as hard as you want. We can do it. But at the end of the day, we have equitable distribution in New Jersey, and I'm going to be able to tell you within that close percentage what you're going to get and what he's going to get, okay? It's no mystery. I'm telling you right now, I'm a mind reader. I've done 500 of these things. I know what's going to happen with this particular judge and this particular facts, okay? If you want to litigate this case, fine. It's not going to affect the outcome one single bit, and at the end of the day, all the money that was going to go to your children are going to go to me and the attorney on the other side here. All right? So you've really got to look at this as a business problem as opposed to something emotional. Let's resolve the case now so you have some money left over at the end of the day. And oh, by the way, when the money runs out, so do we. When that retainer's gone and you have no more money, you're going to be pro se in family court. Okay? Okay. Here is alimonies that have not been touched, rehabilitative and limited duration. Take a look. Again, this is still part of the same statute. This has not been touched by the new legislation. An award of alimony for a limited duration may be modified based upon changed circumstances. Now, this is Lepus versus Lepus stuff. And I'm going to tell you now, you'll see momentarily, that my legal opinion is that Lepus versus Lepus has been partially abrogated by the new statute, where the legislature will go in and tell us specifically, statutorily, what constitutes changed circumstances within the meaning of the statute, okay? Now, I'm not suggesting for 1 second that Lepus versus Lepus has been completely abrogated by statute, but I'm telling you, it has certainly been, for want of a better term, narrowed. The Supreme Court of the Appellate Division will tell us the extent of it later on. Back to the statute, though, dealing with limited duration alimony for initially, and upon the non-concurrence of circumstances that the court would found would occur at the time period of the award, the court may modify the amount of the award, but shall not modify the length except in unusual circumstances. In terms of the length of the term, the court shall consider the length of time it would reasonably take for the recipient to improve his or her earning capacity to the level where the limited duration alimony is no longer appropriate. So there's got to be a beginning, a middle, and an end. Here's rehabilitative. It's going to be awarded based upon a plan in which the payee shows the scope of rehabilitation, the steps to be taken, the time frame, including the period of employment during which the rehabilitation will occur. An award of rehabilitative alimony may be modified based upon either changed circumstances or upon the non-occurrence of circumstances the court found would occur at the time period. Here's the key section. This is the amendment. The section is not intended to preclude the court from modifying alimony awards based upon law. They had to remove the word permanent there because we don't have permanent alimony anymore. Under E, reimbursement alimony may be awarded under circumstances in which one party supported the other for an advanced education, anticipating participation in the future of the earning party's capacity granted by that education. You'll also see a parallel part of this dealing with retirement, where they're saving for retirement jointly, or they expect they're going to go on a big trip, or they bought or they're planning on buying a retirement home. You'll see the same thing here. The key to this is there's been an abrogation of the ability of this to be modified by the court. An award of reimbursement alimony shall not be modified for any reason. So that's off the table. If you have this specified, you got to tell your client, this is the way it's going to be. You're not going to be able to come back here and get this modified later on. On durational, open durational alimony, nothing in the section shall be construed to limit the court's authority to award open durational alimony, limited duration alimony, rehabilitative alimony, or reimbursement alimony separately or in any combination as warranted by the circumstances. Okay? Now, this next section deals with people who have been convicted of crimes and the public policy against them getting alimony when they've committed murder, sexual assault, and things of that nature. Nothing really that we need to discuss here. Okay? I want to discuss modifications to alimony, okay? And the first part that we need to talk about, this is where we're going to get into the military and police, deals with retirement. Retirement, okay? Pension, of course, is a major issue. We'll talk about that momentarily. But the thrust of the legislature here is that people should have a right to retire, to see their income go down, which is a normal occurrence in retirement, and not be burdened for the rest of their life with alimony. So an alimony award can be cut off through the retirement process, and you can, if you retire in good faith, terminate your obligation to pay alimony. All right? Now, look, there's some tax issues here we should talk about for a couple seconds. The idea on this, you know, that you're in your married life, you're working, she's working, everybody's paying the top marginal rate for income tax purposes, and then the idea is that when you're retired, your income is going to be substantially less, but your expenses will be less as well. You'll be paying a lower marginal rate because of the decrease in your income, and you may also have income coming in as a result of capital gains, which will be taxed at a much lower rate. So all these things are, you know, in the mix when we're talking about retirement, notwithstanding the pension stuff, which we'll get into in about 2 seconds, okay? So let's take a look and see how the legislature is going to treat the termination of alimony based upon retirement. Alimony may be modified or terminated upon a prospective or actual retirement of the obligor. So here's the presumption. Now remember, in the civil context, the legislature can create all the presumptions they want. These are true presumptions. We use the bursting bubble theory in New Jersey so that if you can disprove one of the basic facts, the presumed fact kind of goes out the window. And the legislature tells you exactly how to go about either supporting the presumption or rebutting the presumption here. So here's the rebuttable presumption. There's a rebuttable presumption that alimony shall terminate upon the obligor spouse or partner, which means civil partner, attaining full retirement age, except that any arrearages that have accrued prior to the termination date shall not be vacated or annulled. So this would be a public policy issue to keep people from running out the clock, so to speak. They're a month or a year or 2 years behind in their alimony payments. The fact that they've retired is not going to extinguish that debt. The court may set a different alimony termination date for good cause shown based on specific written findings of fact and conclusions of law, again, in order to make a good record for the appellate division. Rebuttable presumption may be overcome if, upon consideration of the following factors, and for good cause shown, the court determines that alimony should continue. So you got two things going on here. Number one, proof on one of these factors you're going to see, and number two, proof that there's good cause shown. I think the presumption, the burden of proof is preponderance of the evidence for this. So here we go. Ages of the parties at the time of the application for retirement, ages of the party at the time of the marriage or civil union, and the ages at the time of the entry of the alimony award. The degree and duration of economic dependency of the recipient upon the payor during the marriage or civil union. Whether the recipient has foregone or relinquished or otherwise sacrificed claims, rights, or property in exchange for a more substantial or longer alimony award. Duration and amount of alimony already paid. Health of the parties at the time of the retirement application. Assets of the party at the time of the application. Whether the recipient has reached full retirement age. Sources of income earned and unearned. Ability of the recipient to have saved adequately for retirement, and any other factors the court may deem relevant. Again, that's the catch-all for equitable purposes. Statute goes on to say, as a modification to K, if the court determines for good cause shown based upon specific written findings of fact and conclusions of law that the presumption has been overcome, then the court shall apply the alimony factors as set forth in B, those are 14 factors we talked about earlier, to the current circumstances in order to determine whether modification or termination of alimony is appropriate. So you may not get out of it completely, but you may again enjoy a substantial reduction in the alimony if you can prove these factors. If the obligor intends to retire but has not yet retired, the court shall establish conditions under which the modification or termination of alimony will be effective. So if you have a client who's looking to retire in X amount of time, now is the time to start thinking about getting into family court to terminate or modify the amount of the alimony, okay? Because you can actually get in there now and set it up ahead of time prospectively so that when your guy does want to retire, everything will be in place. Here's number 2, where the obligor seeks to retire prior to attaining full retirement age, as defined in the section. The obligor shall have the burden of demonstrating by preponderance of the evidence that prospective or actual retirement is reasonable and made in good faith. Okay? Both the obligor's application to the court for modification or termination of the alimony and the obligee's response to the application shall be accompanied by a current CIS, because remember, it may be years before from the last CIS. All right? They might have done it 20 years earlier, so things have changed. So you need a current CIS and other relevant documents as required by the rules of court, as well as a CIS and other documents from the date of the entry of the original alimony award and from the date of any modifications that you had in the interim, because there might have been some other litigation in the intervening time period. Okay, so tell your client they're going to have to do a current CIS. In order to determine whether the obligor has met the burden of demonstrating the obligor's prospective or actual retirement is reasonable and made in good faith, in other words, you're not doing this to get out of paying your alimony, here's the following factors the court will consider: health and age of the parties, the obligor's field of employment, and generally accepted age of retirement in those fields. Stop, time out. Okay, here's where we got to start getting into police, military, fire, corrections officers, okay? These are individuals who are going to retire willingly or otherwise at a much younger age than other individuals. The comparison I like to make is the Superior Court judge is going to retire at age 70. A lot of these police officers are going to be out at age 50, okay, or 55. I think state police is mandatory retirement at age 55. Now, the other thing for the police, you reach a stage at some point, and I don't know much about it, but for pension purposes, there's really no incentive. There's no marginal benefit. Well, why am I talking to you?
Exactly.
Tell everybody. I mean, at 30 years, you're not getting any marginal increase in your pension benefits,
That's
right?
it, yeah, you max out at 70%.
So there's no point in it.
There's no point in staying.
And the other part of it is that, it's meant to be a disincentive for you to stay. They don't want you to stay. They want you to get out so younger people coming up through the ranks can have their shot at it. There's something else that, this is of particular importance to the police. I'm not so sure how relevant it is to military, but it might be. But certainly for police. It is not unusual for the police to die very, very soon after retiring. And some of this is a function of just lifestyle change. Being a police officer, especially for 25 years, takes a lot out of you. You're seeing the worst part of humanity, living a very unhealthy, sedentary lifestyle for the most part. It's aggravated by drinking and smoking, if you're involved in those things, high stress, and a lot of frustration. And it's just not unusual to see people, who are police officers to die of cancer, heart disease, lifestyle-related illnesses very shortly after retirement. Do you disagree with that, Patty?
No, actually, studies have shown that our life expectancy is in the 50s.
Right, and for reasons, but you've known guys who retired and died pretty quickly within the first year afterwards. A lot of the times it's depression too. In the movie we saw earlier on today, the New Centurions, George C. Scott is the star of the movie, and in the plot of the movie, after he retires, I don't think he's retired for more than 6 months, and he blows his brains out. He just can't adjust to life as not being a police officer. So kind of all these things are in the mix. And you're going to see that plays a factor in the statute momentarily. So anyway, obligor's field of employment, again, when you see police, fire, military, corrections officer, all kinds of antennas should be going up in your mind that these guys are going to get special treatment on retirement. Not only in terms of the age of retirement, but also how long are they going to be alive to be able to continue to receive retirement benefits, okay? When the age of the obligor becomes eligible for retirement at the obligor's place of employment, including mandatory retirement dates or dates upon which continued employment would no longer increase retirement benefits. That's really for police, okay? This last one, C. And the idea, you can keep going working, but there is no point in it. It's a disincentive to continue working. Obligor's motives in retiring, including any pressures to retire applied by the obligor's employer or incentive plans offered by the obligor's employer. I want to mention to you two things. On police and military, many times they're going to ask you or pressure you to retire because of disciplinary matters, okay? Maybe not be enough to get you kicked out necessarily, but they're pressuring you because you're a problem police officer, you're a problem soldier. They just don't want you there. They want you gone. And they'll put pressure on you saying, look, you resign now, retire now, and you'll get your benefits, but we want you out of here as of yesterday. And there's periodic reductions in force. These are political questions and economic questions. I think we've just gone through a couple of reductions in force. I saw they had one in the Navy where they got rid of like 17,000 petty officers or something like that. Some enormous number of people. Just a general reduction in force because of economic and political issues. But that comes up especially in the context of military personnel. State workers also every 5 years, not 5 years, but every 10 or 15 years, again because of political and economic factors, the state will do an early buyout and say to people, if you retire now, we'll give you 5 years credit towards your pension, hit the bricks. It becomes a tremendous incentive for people to retire. So that's kind of reflected here in C. D, the obligor's motive in retiring, including any pressure to retire applied by the obligor. Okay, that's D, I'm sorry. Okay? Here's E, reasonable expectations of the party regarding retirement during the marriage or civil union and at the time of the divorce or dissolution. Remember, before things go south, so to speak, they may have had great plans for their retirement together. Condo at the beach, condo in Florida, vacation home in the Poconos, world tour, and they've taken affirmative steps to do this, either by paying for the land, have a mortgage on the condo, might be a timeshare. They have all these plans that they've made where they've pooled their resources with this in anticipation of what their retirement was going to be. That's not going to happen now. But that goes into the mix here. Ability of the obligor to maintain support payments following retirement, including whether the obligor will continue to be employed part-time or reduced work hours. Now, not everybody is going to be able to live on his retirement, so one of the questions the judge has to ask is, are you going to be employed in any capacity, even on a part-time basis, working at McDonald's? How much money do you anticipate on earning during that time period? That's very important. It goes into the mix here. The obligee's level of financial independence and the financial impact of the obligor's retirement upon the obligee. And it may be zero. She might have all the assets, or she may be the beneficiary of some type of a trust, or she's going to inherit a lot of money from her mother, something of that nature. That goes into the mix as well. Here's the equitable one. Any other relevant factor affecting the obligee's decision to retire and the party's respective financial position. That's modified by this. If the obligor intends to retire but has not yet retired, the court shall establish the conditions under which the modification or termination of alimony will be effective. So you can do all this ahead of time and have a court order setting it up so that everybody knows what's going to happen and what the termination or modification date is going to be and what the triggering mechanism will be for that. This is just the same as estate planning, okay? And you really owe it to your current clients, especially the ones who are police and fire, to kind of keep this in the back of their minds, all right? Now, here is one that has relevance to people who are, their divorces are done, they're paying alimony now, they want to retire. You may want to write a letter to your clients alerting your clients that this is in the mix now, okay? Take a look. When a retirement application is filed in cases where there's an existing final alimony order or enforceable written agreement establishing prior to the effective date of this act, so this is all going to be pre-September 10th, 2014. The obligors reaching full retirement age as defined in this section shall be deemed a good faith retirement age. Upon the application by the obligor to modify or terminate alimony, both the obligor's application to the court for modification or termination of alimony and the obligee's response to the application shall be accompanied by a current CIS or other relevant documents as required by the rules of court, as well as the CIS or other documents from the date of entry of the original alimony award and any other subsequent hearings that you had along the way. So you need complete CISs, one from the original one, anything in the middle, and then a current one. In making its determination, the court shall consider the ability of the obligee to have saved adequately for retirement, as well as the following factors in order to determine whether the obligor, by preponderance of the evidence, has demonstrated that modification or termination of alimony is appropriate. So you may want to write letters to your clients that are out there, especially the ones who are older and, they're getting to the point where they should at least be thinking about retirement, and tell them, come on in and see me. We may be going back to court. You have nothing to lose. This could be beneficial to you. Here are the factors: age and health of the parties at the time of the application, field of employment, and generally accepted age of retirement in those fields. Remember, police, military, it's going to be different than the Superior Court judge, okay? And then you have everybody kind of in a range in between. Age when the obligor becomes eligible for retirement at the obligor's place of employment, including mandatory retirement dates, or dates upon which the continued employment would no longer increase the retirement benefits, we talked about before. Again, a major factor with police. Obligor's motives in retiring, including any pressures to retire. We talked about that a moment ago. Reasonable expectation of the parties related to their retirement during the marriage. Ability of the obligor to maintain support payments, including whether or not he's going to work. Obligee's level of financial independence. She might have all the money she needs. Any other relevant factors. Here's number 4, dealing with assets. Assets distributed between the parties at the time of the entry of the final order of divorce or dissolution of the civil union shall not be considered by the court for purposes of determining the obligor's ability to pay following alimony. And that might have happened 30 years ago, okay, depending on how long this has been going on. Please be mindful of this, though. You can't, you're not going to get a double credit, so to speak, all right? Now, the next 2 sections deal with changed circumstances. And the changed circumstances they're going to address are income changes to the person who's paying the alimony. And the world is divided into 2 sets of people: those who are employed by a third party and those who are self-employed. And there's a different test for each one of them because you have different income factors. The people who are employed by a third party, really lots of times they get laid off, the place goes out of business, whatever it is. You have circumstances that come up beyond their control. The test for that, you're going to see, is subtly different than for people who are self-employed. Okay, because many times you can cook the books and adjust your situation in such a way that you're not getting a full picture. So the first category of people are those who are employed by a third party. Okay, now they have changed circumstances coming up in terms of their employment and their income. Remember, I told you before that I thought that lepus versus lepus was partially abrogated by the statute, and this is one of those areas where the changed circumstances is set forth in the statute, okay? Let's take a look. This is under K. Non-self-employed party, so somebody who's out there got a job, okay? Seeks modification of alimony, the court shall consider the following factors. Reason for the loss of income. My place went bankrupt. Under the circumstances where there's been a loss of employment, the obligor's documented efforts to obtain replacement employment or to pursue an alternative occupation. Under circumstances where there's been a loss of employment where the obligor is making a good faith effort to find remunerative employment at any level in any field. How come you're not working at McDonald's if you can't find a job as a brain surgeon? The income of the obligee. What's she doing? Her circumstances and her reasonable efforts to obtain employment in view of the circumstances and existing opportunities. Impact of the party's health on their ability to obtain employment. Again, the loss of employment may be related to injury, to illness. Could be something that happened on the job. You might have a workers' compensation issue involved with it. Severance or compensation or an award made in connection with any loss of employment. So that you might have an LAD issue going on here. Could be a million things, all right, but there might be money coming in. Severance is really not going to be significant, I wouldn't think, under most circumstances. Any change in the respective financial circumstances of the party that have occurred since the date of the order for which modification is sought. Reasons for any change in either party's financial circumstances since the date of the order for which the modification is sought, including but not limited to assessment of the extent to which either party's financial circumstances at the time of the application are attributable to enhanced earnings or financial benefit received from any source since the date of the order. 9, whether a temporary remedy would be fashioned to provide adjustment of supporting award from which modification is sought. and the terms of any such adjustment pending continued employment investigation by the unemployed spouse or partner. And here's the equity part, any other factor, all right? Again, relevant to fairness and it'll related to fairly and equitably deciding the application, okay? Here's the modification on number 10, though. There is a time limit on this because they don't want people running into court every 3 seconds. I've been laid off for a week now, you know, and I can't find a job. I want relief. No. The legislature has set a 90-day cap on this, so you've got to be out of work for a period of at least 90 days before you have standing to go in and bring this application, okay? So, you know, tell your clients they should be doing their best to try to find replacement employment in between that time, because you want to build a track record after the 90 days is up that you say, hey, you know, Your Honor, my guy's been working, he's looking real hard and trying to find a job, but it just keeps getting tougher every day, all right? Put that in the certification. You can actually sing that part. You like how the legislature writes these statutes? They couldn't say it any better than this. Under circumstances where changed circumstances arise from loss of employment, the length of time a party has been involuntarily employed or has an involuntary reduction in income shall not be the only factor considered by the court when an application is filed by the non-self-employed party to reduce alimony because of involuntary loss of employment. The court shall determine the application based upon all the enumerated factors, all 10 of them. However, no application shall be filed until the party has been unemployed or not been able to return or obtain employment at the prior levels or both for a period of 90 days. Court shall have discretion to make any relief granted retroactive to the date of the loss of employment or reduction in income. So what I would do basically is tell your guy you got to be unemployed for 90 days or have this reduction experience for 90 days. We'll get into court right away as soon as the 90 days is up, but in the interim, read over these 10 factors and see which ones he should be doing to build a record. So when he goes into court and completes the CIS, he's going to be able to show that he did all this stuff. And if there's a hearing, testify to all this stuff. All right, here's L. Now, L deals with self-employment. And remember, you have, you know, the obligor has additional control over the ability to present evidence in these cases because he's controlling his own destiny because he's self-employed. So there's a different test when your business goes bad and you're, you know, self-employed. Take a look. This is under L. When a self-employed party seeks modification of alimony because of an involuntary reduction in income since the date of the order from which modification is sought, then the party's application for relief must include an analysis that sets forth the economic and non-economic benefits the party receives from business and which compares these economic and non-economic benefits to those that were in existence at the time of the entry of the order. You need two people here, guys. I mean, I wouldn't waste my time with this unless I had both a CPA and an economist involved in this, okay? I mean, if you're going to really do this and you're serious about it, you've got to have these people come in as witnesses. You just have to. You can't go in there and wing it, all right? So, certified public accountant who's going to put the books together, and then the economist who's going to be able to project the net present value of the lost future earnings, basically, okay? Everybody got that? Don't waste your time without these experts. They got to be there. Let them do their studies, their certifications, because there's going to be an enormous amount of money at stake here in terms of the reduction or elimination of the alimony. Here's M. When assessing temporary remedy, the court may temporarily suspend or reduce support on terms, meaning I'm going to reduce it until such time you get a job. We'll come back and review this in 30 days, 60 days, whatever it's going to be. Or direct that the support be paid in the same amount from assets pending further proceedings, direct a periodic review, or any other the court finds appropriate to assure fairness and equity to both parties, okay? Here's suspension during cohabitation. Now, let's talk about this for a second, okay? Again, I would be writing letters to your clients, okay, who are paying alimony, because this is an enormous change in the law dealing with cohabitation. When we think about cohabitation, all of us, now we think about a sexual relation, two people sleeping in the same bed every night under the same roof, okay? That's cohabitation. They live together, all right? Everybody kind of understands that. And that's a very broad, accepted definition of cohabitation in our culture, all right? That's not the law, though, in New Jersey. And you're going to see that the legal definition of cohabitation is much more nuanced than that. These parties don't necessarily have to be living together and sleeping in the same bed every night of the week, okay? There are other indicia of cohabitation. And it's important you understand this as an advocate, because if you can make a case that there's cohabitation going on with a former spouse, the alimony is going to end. It's going to terminate, okay? So, my advice to all of you is, if you have a situation where your client's paying alimony and there's a palpable case that can be made that the person receiving the alimony is cohabitating with another individual, you got to get that guy into court, okay? This could be an enormously important source of business, and you'll be doing your client a big favor by bringing this motion to the Superior Court. Again, this is nuanced, it's subtle. Let's take a look at it. Alimony may be suspended or terminated if the payee cohabitates with another person. Cohabitation, so again, this is a discretionary call by the judge. The remedy, if the judge is going to grant it, may either be a suspension of it or outright termination of it. Cohabitation involves mutually supportive, intimate personal relationship in which a couple has undertaken duties and privileges that are commonly associated with marriage or civil union, but does not necessarily maintain a single common household. All right? So you got to start looking for the indicia of cohabitation. Take a look at these two people. What do they do? All right? How do they behave? Do they hold themselves out to the public as a couple? If there's a family event, are they there together? Do they come to the Christmas parties together? Do they show up at events involving the children? Soccer game, graduation, you know, something of that nature, birthday party, okay? Do they show up together for Thanksgiving? Do they hold themselves out generally to the public as a couple, okay? How often do they actually reside in the same house, okay? The statute, as you're going to see in a moment, really pins intimacy, sexual relations between these parties as part of it. They use the word intimacy, but that's what they're talking about under the statute. So there has to be a sexual component to the relationship between these parties. But, you know, it's so broad that you could actually be having like it could actually be bi-coastal, in the sense that he's here, she's in California, he'll pick up and once a month goes out there and spends 2 or 3 days with her, or weekend, or whatever it may be. Then the next month she comes here. They have joint assets, they've mixed their finances together. You know, they're doing things that are going to lead at some point to them being, you know, kind of in a long-term, closer type relationship. Take a look at the indicia. These are just pieces of evidence that you put together to make the argument that there's cohabitation going on. And again, this is all statutory. In assessing whether cohabitation is occurring, the court shall consider the following factors: intertwined finances, such as bank accounts or other joint holdings or liabilities. Now, if you're going to do deposition, you're going to do interrogatories, you're going to be looking for this stuff on the CIS, okay? This is something you're going to look for because this is important evidence. Sharing or joint responsibility for living expenses. Again, this should be reflected either in a deposition or through the CIS. Recognition of the relationship in the couple's social and family circles. Remember, they're holding themselves out, showing up together at the soccer game or the birthday party, whatever it may be. Living together. The frequency of conduct, the duration of the relationship, other indicia of a mutually supportive, intimate, personal relationship, okay? Notice that this is conjunctive, not disjunctive, okay? And other relationships of the mutually supportive and intimate personal relationship. Sharing of household chores. Again, this is something that would come up basically through a deposition. You're not likely to get a straight answer to this in an interrogatory. You're certainly not going to get it in a CIS. Whether the recipient of alimony has received an enforceable promise of support from another person within the meaning of it's NJSA 25:1-5, and here's the catch-all, which you would see in every equity statute, all other relevant evidence, okay? And of course, all relevant evidence is admissible. Here's the modifier for the equitable grant of authority to the court. In evaluating whether cohabitation is occurring and whether alimony should be suspended or terminated, the court shall also consider the length of the relationship. The court may not find an absence of cohabitation solely on the ground the couple does not live together on a full-time basis, okay? So this is exactly what I was saying. This is extremely nuanced. Now, I want to talk about family court for a couple seconds, okay? Because there's a couple things going on here that I want to talk to you about. I know that you have read in the appellate division probably 100 times and maybe 50 times in Supreme Court decisions dealing with family court matters. But especially in the appellate division, they ascribe certain talents and skills to family court judges. They say family court judges have specialized knowledge and expertise in dealing with these very, very gut-wrenching, important issues, okay? And you know what? I guarantee you, you're the Essex County expert here, Frankie. I know on the family court bench in Essex County, there's got to be a couple judges who are just excellent. I mean, they get it. They know what to do. They know how to be fair. They just understand it completely. Would you agree?
Absolutely.
You agree?
I practice mainly in Passaic, but yeah, George Seltzer and a couple of the other guys.
Okay. But I mean, there are judges who are, they meet that definition, okay? And then you get judges who are just kind of rotated in because the Chief Justice, you know, this started with the late Chief Justice Willents. They want judges to have experience, so they kind of rotate them in and rotate them out. And many times you'll be getting a judge who really, they take them many times and put them in family court as their initial assignment, because if you're going to make somebody angry, I mean, viscerally angry and hate you for a decision you make as a judge, it's going to happen in family court. And, you know, sometimes these people, then they get angry and they go see their politicians and start complaining and picketing the courthouse. And if this is occurring at a time when you're coming up for your, you know, 7-year reconsideration, so to speak, and you have a politician who wants to make a name for himself, you know, your local senator can block you, and that's the end of your ability to be a judge. So what they do sometimes, they'll put the new attorneys, the new judges, in the family court, let them go there for a year or so, and then yank them out, so that anybody they've made angry in that time period has 5 years to kind of cool off, or this controversy has 5 years to go away. But it hurts you as a family court attorney, especially when you have a difficult case, because you may have a judge there who just doesn't know anything about it, okay? It's not the judge's fault, but there's a learning curve here, a very steep learning curve. And being a good family court judge is just like a 24-hour-a-day job. You know these guys are sitting at home on a Thursday night reading briefs and getting ready to go. You know, it's not unusual for them to be up 10, 11 o'clock at night reading briefs to get ready for the next morning for motion day. Am I exaggerating this? You know, I mean, I'm telling you, this is the way family court works. It's a policy. I don't know that it's necessarily a good policy.
They burn out.
Well, the only counties that may be good policy is where they have one judge sitting in family, so they
Right.
need the judges to understand a little bit. So, but in Essex County, Morris County, Passaic County, well, you know,
In my
why
county,
do you need to rotate judges around?
you know, I got to tell you guys a real quick story. In my county, something happened which is as rare as Halley's Comet. They took a guy from the public defender's office and made him a Superior Court judge. It never happens, okay? These are always going to be prosecutors, first assistants, career prosecutors, politically wired guys, you know, municipal court judges occasionally. Very, very seldom is it a public defender, all right? But this particular guy, when he was a public defender, he specialized in juvenile cases, and he became a nationally known expert in representing juveniles and the whole process of, you know, juvenile justice. So, by some fluke, they actually put him in family court in doing juvenile cases, because that was his field of expertise. And they left him there unmolested for 25 years, because the guy's a superstar. I mean, he just knows everything there is to know, and was a pleasure to appear in front of, but he just got it. He knew what to do with these children. And they kept him there the whole time because he was a valuable asset. He just retired a month or so ago. But the point I'm trying to make is, you know, it's a shame that you get people who develop expertise, who really get it, and then move them out, sometimes for disciplinary reasons. I mean, that's not unheard of, too, where you'll make somebody angry in the judiciary and they just are going to take you out of criminal where you've sat for the last 20 years and punish you by putting you in landlord-tenant court, you know. These things happen, unfortunately, but it's just the nature of the beast, so to speak. But I did want to make this point that you really need, some of these issues are so complicated and nuanced, and these issues with the children and all these things are so complicated. You really need judges who know what the hell they're doing, okay? And it makes your job as advocates so much easier when you can go in and talk to a Superior Court judge who gets it and knows what's happening. Does everybody kind of agree with that? You know, so you know, and I agree, Eric, you made a very good point about burnout, because they do burn out. There's a lot of emotion going on in here, you know. You know what makes them burn out? When they get lawyers who don't know what they're doing. And they get these stupid motions that don't mean a thing. Here's the definition of full retirement age. It's statutory. They're stealing it right out of the Social Security Act. So full retirement, I guess, is it 66 or 67 now where you get your full Social Security benefits? Anybody know?
Depends on the half now.
The 60
66 now. Yeah, 66 now.
I don't know. I'm only 32 myself. So 66 and a half is the, is that the age? I don't know. I mean, you can retire, I guess, earlier on 62 and a half, but you don't get your full benefits?
Yeah.
Okay.
Either 66 or 67.
I was born in '89, so what year?
It'll be 72.
82 in my case. Okay. But I mean, when you get into one of these retirement things where you want to cut off or modify the alimony based upon retirement, okay, unless you have one of these exceptional situations where retirement's mandatory because it just is, this is your fallback position, 42 U.S.C. 416. Again, it may be 67. Again, I think it's a function of when you were born, though. Look at the schedule. So, what do you guys think? You're going to be able to use this to your advantage for your clients? This is the can't hurt. And everybody understands that this really changes the landscape in terms of alimony. By the same token, don't be afraid to utilize this to your advantage to leverage the award of the alimony against assets that are really important to your client, okay? Because remember, you're talking about net present value of dollars today, which are not going to be the same as 5 or 10 years from now because of inflation.